Today I'm going to talk about the Kansas Supreme Court's Pretrial Justice Task Force, which we initiated. Not so much, we'll talk about the report and the contents. I really thought what I would do is emphasize process that we went through so that when you go back to your respective states, you can compare our process to what happens there. And I'm not saying ours is great or the best or anything. It is what we did. And so, and I just want to use that, and I'm happy to have any feedback that we get on this thing. I want to say at the outset that, and this is what I teach a class at Kansas State University on media law. It's media law and ethics. And I tell my students at the first class that trying to talk about legal issues and the law, especially to another group where you're trying to engage them, sometimes causes me to want to say exciting things or controversial things or things that you might disagree with. You've got to understand I'm doing that for our environment here in order to prompt a dialogue. Do not read into anything I say or anything in this program as to how I might rule on a particular case. I can't tell yet whether Kansas is about to get any litigation that might talk more about what it means for liberty and bail, and whether public safety can be included as a criteria for that. I'll show you here in a little bit that our case law in Kansas is a little mixed, a little muddy in this area. I'm not sure how it got muddy. I think it was just kind of a mistake, but I can't tell if there's an energy in our state to bring any litigation up. But my caveat is, just in case there is, nothing I say here is indicative of how we might rule on a case. I just authored an opinion last Friday that I know all of the lawyers who were in the oral argument during that case thought it was going to go the other way, and a unanimous court went a particular way. But I guarantee you the lawyers from the oral argument thought that we were all headed down a different path. And so, these things change and these things develop. So, the first thing to understand is that state courts across the country, occupy a unique place in our democracy. And the public trust in our state courts is essential, as is the need for their independence, their accountability, and a service-oriented approach in what courts do what they do. And in that vein, there's been an increased focus on how the courts order bail and pretrial supervision conditions and post-conviction fines, fees, and surcharges. So while I know you all are focused on one aspect of those three, from the I almost said pressure, I'm not sure that's the right word, but the discussion that's happening among all state courts is on all three. To the extent that post-conviction fines and fees burden the poor, make it impossible for a defendant, a convicted defendant now, to be able to get off the hamster wheel of these obligations, is, in my mind, just as forceful as what you all are focused on and characterizing as an attack. The other thing I want to point out is that I spent 29 years in the practice of law before I I got this new day job. I never did a criminal case. It was all civil. I never got a client bail, just so you know that. I was in in a little tiny piece of a criminal case in federal court one time, but the nature of my practice included representing white collar fraud defendants in the civil context. Well, sometimes they'd get sued criminally or get prosecuted criminally, but those cases all went out to other people, and I just provided the facts. So my point is, you can get into the details of this subject and lose me real quickly, but I think the quality of my reading of this is that I'm awfully agnostic. I honestly don't have any dog in any part of this fight. I'm interested in common sense. I'm interested in fairness. I think you will find that state Supreme Court justices who universally, across the country, have the administrative responsibility for their court system. Most of them are going to be like me, not necessarily someone experienced in criminal law that did a lot of bail work or that sort of thing. And so I'm open to the discussion, and I've been open to what I'm doing here. Well, we know we've got a situation. Statistics as of mid-2021 are showing only about 20% of the jail population in the United States is serving time for being convicted of a crime, while the 80% are being held in pretrial detention. And that naturally draws the discussion. It just naturally does. And so in November of 2018, the Kansas Supreme Court created this ad hoc pretrial justice task force. The cover of it is on the opening slide here. You have a full copy of it in your materials, as well as the executive summary of it. So you've got the full report, an executive summary that the task force prepared, and then you've got my slideshow. And the task force went about the idea of looking into pretrial detention policies and procedures, as well as the alternatives to pretrial detention, and the court's authority to be able to create this task force and launch it on its mission comes from the Kansas Constitution, as it would in every of your state's constitutions. Will say that the Supreme Court has administrative responsibility over the judicial branch. And so it's that declaration from the Constitution that allows us to be able to do that. So again, to the extent that we go through this material, at times I'm going to play devil's advocate maybe. I'm going to ask for your opinion. Because of COVID, because of the condition of the Kansas court system in terms of some technical things that we're doing, this isn't on our immediate burner, but I see some things that are going to be happening in the next couple of years as we come out of this. And so, feel free as we go through here to ask questions, to object to anything I say, but let's just feel free to engage in a dialogue. So in 2018, when we initiated this task force and created it, our then Chief Justice Lawton Nuss, had this to say, that every day Kansas judges decide whether to detain criminal defendants and under what circumstances. These decisions are made amid a national discussion about the alternatives to pretrial detention and the need to ensure that no person is unnecessarily deprived of his or her liberty. And I think, again, that's a common sense kind of approach to this thing. So what the court did was issue an order that charged the commission to do several things: to examine existing pretrial detention practices for criminal defendants, to examine the methods other than pretrial detention that are being used in Kansas courts to encourage court appearances, and ensure public safety. This is just the language from our order. To compare the effective pretrial detention practices that are used elsewhere, to help develop a best practices model in Kansas, to identify any statutory problems that we may have or impediments to the recommendations, to identify any issues requiring more research or data compilation before a recommendation can be made to the court, and identify and prioritize topics in training Kansas trial judges and on the best practices for pretrial detention. Now, notice that this is completely focused on pretrial practices as opposed to those other three elements that have been important and that are being talked about a lot on the state level. We decided just to tackle this one aspect of what is a larger discussion around. Another thing has happened here that to mention, which is that a lot of times people will say that the imposition of court fees, conditions, those kind of things are revenue generating things for the court system. We were able this last legislative session, and well, first of all, Kansas was no different in that respect. There were fees and stuff that would get assessed against a criminal defendant, and it went into the pot. But we were able this legislative session to get the legislature to agree to move our entire budget into the general appropriation for the state. So that's just general fund money. What was good about that was it took us out of the middle of the discussion between groups like in Kansas was there's an organization called Appleseed, the Koch people, the ACLU, all had identified different fines or fees that they thought were particularly burdensome on defendants, where that money went to the court. And those groups would come to us and say, well, clearly these are oppressive kind of fees. You don't mind if we go to the legislature and ask for them to be abolished, right? Well, we have to say, buddy, I mean, that we get that money, and so it's got to be replaced. And it's not that we're saying no to the value and the validity of the issue. It's that revenue can't be gone, can't be missing from us. In Kansas, because of the way we fund the court system, the state pays for personnel, where the infrastructure, the courthouse, the other types of buildings are paid for by the individual counties. And so our budget on a statewide basis is about 1% of the state general fund budget, but it all goes to personnel. So when these well-meaning groups would come to us and say, surely we can do away with this fee or that fee, you're talking about us losing staff because there's no other way to replace that revenue. So that had us in the middle, and we didn't like being in the middle of a discussion that says we really don't care, other than the fact that we can't continue to operate as the way we have. So this change, I think, is very, very strong and good for the state of Kansas, and creates an environment where these advocacy groups can make their case where it needs to be made, which is to state lawmakers, and let them decide whether these are good fines and fees and that kind of thing or bad. Because now all of it's going into the state treasury, not to us. So I think that's a really good development. Anyway, these are the charges that are up on the slide, this is how we charged the task force. You can look at that and decide whether things should have been added or taken away. Again, from my kind of neutral perspective, I don't see anything wrong here, at least as a general sort of nature. Well, after creating the charge for the task force, we had to appoint task force members. So here are the 15 task force members. I was a part of the decision making about these people getting on there. I didn't have any candidates. I later wanted to get Cal on, but the horse was already out of the barn at that point. But the thing that motivated the court in its membership here, first of all, was that it be a controllable group. I mean, it's easy to say, oh, well, we ought to have the bail bonds people and the ACLU and the different associations that are involved, but then it becomes less of a manageable group. So we first picked this group. Again, you can make a decision whether you think this was the right mix or not. But we've got criminal defense lawyers, we've got prosecutors, we've got judges, magistrates, we've got very good people. Our chair was the chief judge of the Kansas Court of Appeals, Karen Arnold Berger. She has a tremendous reputation, a positive reputation in the state of Kansas. And she's one of the most hardworking people you'll ever meet as a public servant. So she was the chair, and she shepherded the group through this. So again, you can make a judgment call as to how well this went. We had one other direction from the court to the task force before they launched their efforts, and that was to seek out and consider the input from various stakeholder groups. That was our way of trying to keep the task force manageable, but at the same time allow people to have a seat at the table, or at least to provide input. And the input that they got, actual input, not solicited, but this is the actual input, came from each one of these entities. Again, I think that's a fairly good representative batch of people to provide input on what is a controversial subject and which has a lot of different viewpoints to it. And again, as someone from the outside, being agnostic, when you get into the meat of the report, when you read this whole document, which is this size, you'll see that there were some strange bedfellows in all this group, at least in my notion. The ACLU and the Sheriff's Association or Koch Industries agreed on various types of provisions. The Kansas bail agents agreed or disagreed on different things, but they didn't align in the way I think most people would think of, conservative, liberal, which tells me that the substance of the issues were getting hashed out in a reasonable way. The task force also received information from these groups that are on here. Organizations like the U.S. Probation Office, so that the task force members could get educated about the federal system. Different university professors who brought a particular expertise to things. The ones I want to point out here are the National Conference of State Legislatures and the National Council of State Courts. Both of those organizations and particularly the National Council of State Courts, truly is becoming a well of information across the country on this particular topic. My point about that is, to the extent you've got a case to make, I would go there if you haven't. There's a lot of material on their website. They travel and bring consultants in, and their perspective is on all three of those issues: detention, pretrial conditions, and then post-conviction stuff. But focus your attention there. Same way with the State Legislature's Council. They are just a well of information that comes out. The other thing that has impressed me about the task force work and its report is that they put everything they did, they put everything they received, even stuff that Cal wrote, is on the website. They have videos of all of their meetings and their various things. So you can actually see the depth of it. Again, you may be critical of what it is they're like. I'm not suggesting anything different. I'm just saying it's all the cards are being laid out face up to play this game. I think that's a healthy way to approach this, but you can decide for yourself whether there's enough in there. So let's start with why the fuss to even do this in the first place? Well, from our court's perspective, we started with the Conference of Chief Justices from a national organization, adopted a resolution that encouraged this kind of informational effort. There have been some federal lawsuits that have, not in Kansas, but there have been some federal lawsuits that have raised the attention level on this subject. You've got a whole lot of social science and statistical research, I suspect controversial from different perspectives, but there's a whole bunch of it out there with these kinds of conclusions. And so as public officials, when you have that kind of data and discussion coming, it's kind of a natural thing to say, let's look deeper into it. And then you've got just the notions of how many people the United States incarcerates, both across the United States, and who those inmates are. And then in Kansas, our numbers are showing that about 53% of those people detained in our county jails are not there because of a post-conviction sentence. They're there to answer they're waiting for disposition of a current charge against them. So there's a lot of population there. You get that kind of number there, and that's what raises the attention of the county commissioners and the sheriffs, because they're providing these facilities. So again, you get that kind of notion, and so it was natural, like I say, to start a task force. Some other perspectives about Kansas. In my work, I always start with the Constitution. And Kansas has a provision, been in the Constitution since statehood, says all persons shall be bailable, and by sufficient sureties except for capital offenses, etc. And then excessive bail shall not be required. I do want to point out, just for grins here, in Kansas we make unconstitutional things that are cruel or unusual. The federal Constitution is cruel and unusual. I don't know what the or means, and we haven't decided that. So in my class, when I'm talking about why should courts be interpreting the Constitution, I show them the Eighth Amendment, federal Eighth Amendment, and the Bill of Rights, Section 9, and I go, that or make a difference? And who should decide that? I've had members on my court who think that or makes a big difference. Someday we'll have a case that decides that, but little footnote. Once you get past the Constitution, you then have in Kansas some statutes that set out how this is supposed to work. We have it in Article 28 of the Kansas statutes. The opening provision in these statutes says the purpose of the article is to ensure that all persons, regardless of their financial status, shall not needlessly be detained. The language in red I highlight because it says when detention serves neither the ends of justice nor the public interest. That's fairly broad statutory language. And I know that in the arguments that you've made to the task force, you've focused on the statutory side. The only thing I want you to pay attention to, though, is the Constitution. You've got to start there before you make your argument about the statute, because it might be that the legislature didn't get it right. You don't want to tell them, too many times, but that's there. And this is so I know this is difficult, if not impossible, to read, but so these are the conditions that the statute sets out, and you'll notice that you've got an and here, so all of these conditions are things that a magistrate or a district court judge is to take into account when deciding the conditions of release. We'll come back to this statute in a minute, but you can see how they're laid out. Then we've got some case law in Kansas, and we have 3 cases. I've got 2 up here, but there's a reason I've laid this out the way I have. So 1978, the Foy case. Notice this last couple sentences here. The amount of bail rests within the discretion. Okay, that's fine. The purpose of the statutes requiring bond from persons accused of crime is to assure their presence at the time and place of trial. Notice there's no mention of public safety, which I know is something that you all emphasize. I'm just saying, that's there. 1987, another case. Bail is excessive when it is set an amount higher than necessary to ensure the appearance of the accused at trial. Again, no mention of public safety. So those are the sentences. Now, let's go back to the statute and the conditions that are here. All of these that are set out, are there any conditions that you see that should be taken into consideration that don't align with coming back to court?
One of the comments I would make is nobody can guess on the future activities of anybody. Right. Some people will not learn their lesson by having to bail or be released on OR. So the second one from the bottom, the likelihood of propensity for the defendant to commit another crime, which is on release. None of us are mind readers. We hope and pray they don't. So that's a tough one.
I understand that, but regardless of how hard or how easy it is, does that factor, which is actually the one I wanted to highlight here, so you get it right. Yeah. My question to you is, what does that have to do, regardless of whether you're right or wrong about propensity to commit another crime, what does that have to do with an appearance at the next court hearing? Nothing. So, is that provision unconstitutional? I'm going to make your argument in a minute. But I think that's a fair question. I don't know how I'm going to, by the way, for the recording, I don't know how I'm going to answer this if it ever comes up. There is a third Kansas Supreme Court case. and it's called State versus Robertson. And it actually mentions both the need to have the defendant appear at the next court date, but also the notion of public safety. The problem, so that's your argument. You want to cite to Robertson. You want to embrace it. You want to have t-shirts made that talk about it. The problem is, going back for a second, Robertson comes between the 1978 case and the 1987 case. So to the extent Robertson is sloppy, maybe, does the 87 case clean it up? And I'm saying this because you guys make the argument about public safety. Fine. I'm just wondering how that puzzle piece fits into the mosaic constitutionally. I don't care about its merits. I care about whether the law lets it be there, right? So, again, that's just something for you guys to chew on. So, this is what I want your input on. So this was the task force overarching principles for their recommendations. There are 19 recommendations that you've got there. All defendants presumed innocent, liberty is the norm, and detention should be the exception. Judges should first consider whether non-monetary conditions are sufficient before requiring a monetary bond, and conditions of release should be at the least restrictive to assure a defendant's appearance and the protection of the public. If those are the overarching principles, I guess two things I want to know from you, I'd be interested in. Is there anything missing? Is there anything wrong with the ones that are up there? Is there, and I'm asking because I'm agnostic about this. I've got to administer this provision. Is there anything there that shouldn't be there? Let's start with that one. Or are those okay? Because they said so. I mean, I'm not making the case, but do you think they shouldn't be least restrictive? I mean, why would you want to be more restrictive than you need to be to assure the defendant's appearance or to protect the public? Is there a reason to be more onerous on an unconvicted defendant, presumed innocent? I mean, those would be at least some of the things that would be said.
Well, one of the restrictions is no contact with the victim in a domestic violence for 72 hours. Some judges go all the way there. That come to be because of the 3 murders, suicides that happened in Riley County, and that's why I was on that committee to help pass that bill to get that as restrictive. And we toyed with this right here. You're making more restrictions, yeah, but it's for the safety of the victim and things like that. Is that where you're going with that?
I'm not going anywhere. I'm asking your input.
That's the reason we did that.
I'm honest. I mean,
but that was
okay.
The biggest argument was that's being more restrictive. Why are you saying they can't have contact? They got to go to work, they got to live at home, this and that. And I remember going through that.
But let's go back to our comment about we can't really predict propensity. And honestly, we don't convict people on propensity except in sex crimes. Because they made an exception to the evidence. But if we don't know, then the other side of the argument is you're imposing a more restrictive thing on a defendant when somebody just doesn't want to take the risk that they might do something. And is that a legal thing to do? I'm not saying there's a yes or no answer, honestly, Dave. I'm really not. But the reason we end up with so many people in jail, in the United States, more people in jail than other countries, is if judges get more spooked about the risk, I mean, than anything else. The other question I have for you is, if we're worried about public safety, how does any amount of money relevant to that factor? Or does it just mean we've made it so that somebody can't get out of jail? Because if I'm a really rich person and I can afford to post the bond, is the public any more safe? Depending upon what my characteristics are. Again, kind of a neutral person here. I think those are hard arguments to make, just from where I'm standing. I understand, I'm just saying, I think those are hard arguments to make, so I would encourage you to do them with precision, so that they can, and not just conclusory kind of things. You've got to make your case there, because I would go into it a little skeptical, because I can't correlate money to public safety when it's a rich person. Why would we let a rich person out if they're a threat to the public? Well, they could afford to post $1 million. Really? The public's not any safer after they did that. Doesn't seem to me. So that's just the pushback, but yeah.
So on that note, one of the things that they use against us quite often is that you just said they can't afford. Well, look what O.J. Simpson afforded, and look what it got him. Anybody else might not have had that position. So they use that bullet against this industry and us for charging a fee for a product that we didn't set the amount of, okay? I just believe you have to have skin in the game. And part of the way skin in the game in the criminal justice system is having to, you can win something or you can lose something. So the argument about you saying afford or what can they or can't they afford, I think that gets overused. I'm not saying by you, sir. It gets overused against them.
You can't offend me, because a lot worse has been said about me. Trust me.
So I hope you get what I'm saying. I kind of circled it up, but I just hate that argument.
I just think you have to make your case, again, from my perspective, with precision, because if a bond is set that we know the defendant can't afford, then aren't we just throwing the defendant in jail? And for someone who's presumed innocent, how does that work? I mean, how do we reconcile that? Well, I think we just have to get better at the decision making so that we're not knee-jerking one way or the other. I mean, I think that's ends up being, it's never going to be perfect, right? There's always going to be a gray area. Yes, sir.
It's not a science, and it's not a one-size-fits-all. It's each individual case. That's the tricky part.
Right, and that individual decision-making needs to be data-driven as opposed to driven by some elected, let's just say an elected magistrate's fear that if I let somebody out and something happens, not based on any real information other than just I don't like taking risks, then you got your county jail full.
With bail bonds, it's I say fairly easy. You can just look in their past records. If they have a failure to appears in there, then probably needs to be a bond set.
Well, and there are legitimate factors that I think fit into the decision making.
Statutes have built that in.
You know.
We have, well, I'm not.
Yeah.
If you wanted to make the pro-bail argument, you could cite statistics that people who post through commercial surety do have a lower recidivism rate, but then just on like a regular public safety rate level, like on a human level, you really can't predict what somebody will do. You know what I mean? Statistically, you could say there's a correlation between people who post through commercial surety and lower recidivism rates, but like Ms. Rowan said, it really is case by case. It's hard to
Right,
predict.
and I'm just saying it really needs to be case by case, right? And not just because I'm worried. You know, because I don't know, I'm going to err on the side of having a more oppressive bond or something that I know someone can't. Because I'm getting to my point about collection of data, so The task force said we can't lose sight of the fact the majority of the people involved in criminal justice system across this country appear in court as ordered and do not commit new offenses. So even at the highest risk levels established by the most frequently used pretrial risk assessments, the majority will not be arrested for any new offenses while on pretrial release, let alone a violent crime. You agree or disagree with that?
Totally disagree.
Okay? Why?
Because you're saying that you can predict just by looking at someone that, hey, you're not going to reoffend just because they're...
Is that really saying that?
Verbiage.
I think that's said. I mean, let me push back.
Sure.
When I read that, what I see is a generalization of a problem, but if you're looking at probabilities, you've got some probability here, so doesn't that warrant more work, more detail on this is what I'm getting at here. Anybody else got, yeah.
Is that a fact or a statement?
No, that's a statement from
It's a statement from the task force. I'm saying, do you guys agree or disagree with
So
it?
it's not a fact.
No.
They didn't do any statistics to come up with that statement.
Well, they studied all that stuff I showed you, and you can go on the website and look at all the stuff they looked at.
So that's a fact.
And they came up, that's their conclusion from this.
I don't believe that. I'm telling you, the people that we deal with just commit crime after crime after crime after crime. And am I wrong? Am I
No,
wrong
you're
when it
right.
deals with that?
The judges see
And-
that too.
And a lot of times they're currently, usually they'll get arrested, they're out on bond, they won't offend, their case will be completed, and then a few months later they offend again. I mean, it's just a lifestyle thing. I'm not trying to be ugly. I mean, they're not necessarily bad people. They just, sometimes they are. I mean, they make bad choices.
So what do we do with that? What do we do with that anecdotal experience that you have? Don't discount it. I'm not trying to do that. But what conclusion do we come up with when we've got somebody in front of us and we need to set bail? That's
Oh, right, I understand.
yeah, Nick.
There's two things. The majority could just be 51% versus 49%.
I understand.
And then, of course, there's that segment, the repeat offender, where they're, based on their history, it's kind of easy to tell that it's a habit. So that repeat offender needs to be treated a little differently than the majority. Because the majority, you can throw in traffic, you can throw in misdemeanor, you can throw in whatever you want, and then the majority could be 51%.
Right, but we want to make sure our jails aren't full of people that shouldn't be there. And so, to me, coming up with this conclusion based on all that they've seen, I read this to be, this means we need to keep digging. We need to have a thoughtful, analytical approach as best we can, knowing in the end it's still going to be some magistrate out in some small county in Kansas that's going to have to make the decision. But we've got to work to provide criteria that help guide what is ultimately a judgment call, right? I mean, that's what I think out of this. Yeah.
When I asked Arnold Berger about that, I said on your 53% of people that are in jail with this, I asked her how many of them were felonies. They hadn't checked that variable. How many had other holds from other jurisdictions? They couldn't answer those questions. They didn't gather enough data, honestly. And I'm not gonna bash it because it was a great thing, and I know
There's a
counsel-
reason why they didn't answer it, and that's what he's getting to.
Yeah, okay. Then I
About
didn't
to
want
hear it.
then I'm not going to say.
Well,
No, you're fine.
But I didn't want to interrupt. I don't want to.
but I need, help me understand. I get that if that number includes people that are on a hold from another county or state, then that's why they're in jail. So you ought not to be thinking in terms of, is that a function of the bail that was set for the crime that they're, But what difference does it make whether it's felony or misdemeanor when we're talking about people sitting in jail?
Okay, I'll tell you. Because with the felonies, and I don't have accurate data, but out of that 53%, there is like 70% are felonies, and out of those 70%, most of them, and I don't know, I'll say 60, 70%, is in excess of a $100,000 bail. It's unaffordable. And if they did have affordable, if a bondsman's going to take that risk, the bondsman has to make sure he has $100,000 in collateral, because he's wanting to make sure that if they don't show up, I can't pay $100,000, and they don't have family or friends that can put up the collateral. So it really is out of reach.
I still get back to but doesn't the $100,000 have to be supportable
To the crime.
to the defendant? Not only just the crime and the defendant. I'm willing to. I understand a defendant that's got a long criminal history of not showing up or whatever, but that's criteria that you can use to defend the decision, and so it's just drilling down further into the facts to be able to make some decisions. Okay, that's good. Here was another one, setting a bond with. I'm sorry.
Yes, but looking at it from that standpoint, you get a homeless person that's charged with murder, can't afford any bail, so it's fair to the defendant.
Right, but there you've got, you're going to have evidence. What's being charged with murder is one thing, but what's the evidence supports it? Again, you can run criteria on this to decide what the bail decision ought to be. Right?
I agree, but I think there has to be some amount of accountability, no matter what the person's economic standard.
So what do you mean by accountability?
Okay, they have to have something to get them invested in the system as to what they've done. In other words,
they're presumed innocent. They're presumed innocent.
Okay, that's true. I agree with you. But you have the situation where it was on video what somebody did. Now, of course, they haven't been convicted yet, but there's pretty hard evidence that they
Sure. But now you've got, the thing I want judges to do when they're setting bail is figure out how they would explain what they did, to a federal judge, just to make it pretty blatant,
In my 1 year of law school, one of the first things I learned is the presumption of innocence is only a factor in a courtroom. Is that correct or is that not correct?
Sure.
So what
it
you
doesn't-
said to him, I'm just saying, when the cops arrest somebody, they're not arresting them and going, well, you're innocent, but I'm going to prove you're guilty. They are presumed to have committed the crime. The only time they're innocent until proven guilty, or you're presumed innocent, is inside of a court.
The arrest occurs because of probable cause. Conviction's going to occur on beyond a reasonable doubt. Big gap in between. I'm just saying, if someone, we don't know anything other than Joe Smith got arrested for murder. Bad crime, right? But we don't know that he's associated with anything. And so because it's a big crime, we're going to put $1 million on it, and the guy has to sit in jail. There's more to talk about than just is where I'm at on this thing. Just me coming along. Okay. I don't mean to wear you out here, so just maybe I already have, but stop me and I'll jump off at any point. But setting a bond with the intention that it will require the defendant to remain in jail, or setting a bond as a means to punish a defendant before trial, is prohibited. That's their notion. Agree or disagree?
It's definitely a fair notion, yes. Everybody says that.
Okay, so I want to focus on where I think Kansas is going with all this, and that's the last thing I've got here, other than just your questions here. So there are 19 recommendations to the task force report. You have those, they're easily reviewed in the executive summary, but they're also laid out with the pros and the cons in the big report. So they'll say, here's our recommendation, and Cal didn't like it, and Koch Industries and the ACLU and the sheriffs did, or whatever. Or everybody loved this recommendation. But that's all laid out there. I want to focus on what is recommendation 10 in your materials. Starts out here, although the cost may be great, the task force believes the early appointment of counsel may be one of the best investments that can be made to reduce pretrial incarceration and assure individual constitutional rights. I believe the Kansas Association supported this recommendation.
We did.
Yeah.
Okay. I want to take exception to the first prepositional phrase. Although the cost may be great, I wish it wasn't there. It's going to scare the folks across the street in the legislature. The reason I don't think it's as meaningful now as it was to the task force is because of the pandemic. We structured everything so that, because people kept getting arrested, right? So we had to come in, we'd have first appearances on video. The system is kind of set up that way. Generally speaking, I think sheriffs and local judges liked the idea that you could run these appearances quickly, because they could run out of the jail. You didn't have to take anybody out of jail or they could just sit there in a little booth and run one in after the other. Okay, so we're used to that. I have had some judges, local judges, tell me that even though we're back out getting COVID, but we're free, that they're going to continue using these video first and second appearances. So that has caused Chief Judge Arnold Berger to start talking to the public defenders about the idea that maybe this could be done over video and get a public defender, maybe sitting in Topeka, to be able to handle just those first couple of, that first appearance and some of that, so that you get the interaction of counsel and a focus then on the financial affidavit and get that done early. So this may not be as difficult. Yeah.
Okay, I'm not saying it was my idea, but I'm going to say it was my idea because I said.
Oh, I'm so glad I highlighted it then. I didn't know that.
Why don't they have a public defender when the person is arrested? Why can't they have counsel right there to make sure that that person's rights are protected? Because the police, now the Sheriff's Association, we don't want that. Well, I don't think it's a bad idea. Before they even have bail, they have an attorney there to say what they can and can't do. Give them, because when the person is sitting in jail, this is my argument, personally. When the person is sitting in jail, he has no friends. He has nothing. But if you tell him, there's an attorney right here on the screen, it's going to help advise you what to say and not to do, well, what's going to happen? They're going to, I plead the fifth or whatever, I'm not going to say anything, and I choose to have an attorney. Well, that might not be a bad thing. But the idea is at least the court system knows that he had counsel there to help him, because lots of times I think that helps. The other one is I think they need to have speedier trial quicker than they do.
Right.
Absolutely.
So the notion that we could just have more public defenders, that's dead at the beginning. As far as the physical appearance, I mean, our public
Via camera, I said via camera.
our public defenders are, underpaid and way overworked, and they're now starting to build a case about effective assistance of counsel. And again, not commenting on anything, but that's starting to get built. But boy, what we learned during COVID in how to run the court system, I think might be a solution here. And I think getting a lawyer involved early may help keep the financial conditions and everything more manageable. And so we are actually trying to talk to the public defender now about what would this take. And so instead of it being, an army of public defenders around Kansas, we've got the video thing. So we're pursuing that.
Sorry.
Yeah, go ahead.
Not to belabor this, but I'm going to tell you, one of the things they used against us, and they continue to use against us, and when I hear about this case, I get mad, and that's why it's in my phone and will forever be in my phone. I'm going to just read this very briefly. In 2010, Kalief Browder, a Bronx teenager, was accused of stealing a backpack. He spent the next 3 years on Rikers Island because he could not afford to pay a $3,000 bail. Holding steadfast to his innocence, Browder remained in jail without access to his lawyer and at the mercy of the prosecutor, and he was in solitary confinement. That's a broken system. That is not our fault. That is a broken system. I took a kid back from California to Alabama in 2014. 2 years later, he called me and he said, "Mr. Padilla, I'm still in jail and they haven't resolved my case." In Alabama, I don't know if there's anybody here, but from Alabama, they'll continue a case for 6 months. For 6 months with no other cases in between. We have a broken system problem. And when you said a little bit ago about the percentage of people in custody pre-trial, I get sick to my stomach saying, we'll get this system to work faster to get it to where they're either found innocent or found guilty.
Oh, there's a lot of factors going into all that, and it's just identifying. When I first got on the court, we have a process in Kansas where not all cases can go directly to the Kansas Supreme Court. They must go to the Court of Appeals. Then we decide, for the most part, whether a case can come to us. It's called a petition for review. When I first got on the court, it was taking a year for us, from the date of filing of the petition for review, to just get an answer whether we were going to accept the case or reject it. To begin with, that's bad. That's wrong. But the prosecutors knew that it took a year. So when the criminal defendant would win at the Court of Appeals and a reversal and an order for new trial, the state was filing a petition for review knowing it'd go at the bottom of the stack, and so the defendant would have another year before we could decide whether that new trial order would go into effect. Absolutely unacceptable. And the same thing was happening with adoptions and severing of parental rights and child in need of care. So we began our own system of triage. And so if you're a criminal defendant and you win at the Court of Appeals, state petitions for review, it's fair for them to do that, right? Yes. But they go to the top of the pile. So we decide as quickly as we can whether...
Oh, that stops the malicious strategy. I see what you're saying.
Yeah. I mean, it stops the state from just delaying things for yet another year before they even know whether they're going to have a court hearing in front of us. Okay. So I mean, but that's honestly a small thing to do to solve an important problem, but there are a lot of important problems. I mean, the way I look at it. So here's recommendation number 10, real quickly. So my point is, we are working to try to make this closer to reality because of technology. You can look at this other material later, but I wanted to stop here on their other recommendations about data collection because now this is in my wheelhouse. I am the Supreme Court's liaison for what has become a incredible logistical problem of taking all 105 counties that are individually on computer systems and putting it into one web-based system that everybody can access from across the state. I mean, it's tremendous. It's, I think, the biggest revolution in the court system since 1965. I mean, just without getting into the details of it. It particularly is important for the small counties of Kansas because if you've got a little tiny courthouse with little volume out there. Legislators see that and they go, well, why can't we close that courthouse and make people go to the next county or whatever. By doing we can do all this work remotely so that those clerks that are in small counties can help the large counties with their volume, so they're not just sitting around. I mean, we literally have offices where if the clerk needs to go to the bathroom, they have to shut the clerk's office down. And then, and if somebody gets sick or vacation, so it's really hard. This is going to be a tremendous system, very complicated, but it allows us to do this, the data collection. And I think what Kansas is going to be doing, and the thing that has to happen next, is to try to gather data on all of these questions and arguments that you're all making, to see which ones are right, which ones are specious, which ones, the arguments made by other advocates. So our district judges have not been used to thinking outside of the county line or maybe the judicial district line. And so every time I present this project to the district court judges, I say the one thing you have to understand is individualization is being stamped out like a bug. Because we are standardizing everything, So we're going to have to work at it in doing the data collection, but all the forms, everything else is getting to a great extent standardized, and in order to collect this data, it's going to have to be standardized. And I think we can do this one, and we can do the first one, the educate the judges, and the public. We're going to keep working on the judges to start talking about best practices and what things are showing us, and to get more sensitive about this. But honestly, I don't see much else in Kansas happening until we get the data to be able to pound it home. I just think the other things, there's a recommendation in there about amending the Constitution. I mean, everybody gets afraid when the legislature gets close to one of doing that. Yeah.
I'm sorry, Claire was first. You keep trying to raise your hand.
I just wanted to know, initially, you had 16 people up there on this panel. Now, in California, that would never happen. They wouldn't agree on a damn thing. But what I want to know is, how long did this take for them to get to this resolution?
Well, the report itself was issued in November of 2020. We created the commission and charged it in November of 2018, and we had to give them an extra 6 months because of COVID.
That's amazing. Amazing.
And I don't know how much COVID slowed it down. I mean, I wasn't paying attention. I waited until the report was done.
I'm still stunned.
But I hope, well, and then I'll just get through all these slides.
I did have some.
I'm sorry, you had a question.
Could you give me the nutshell on what data collection is? What data are you talking about?
You're going to want to know felony versus misdemeanor. You're going to want to know prior criminal history. And I'm not well versed enough to be able to tell you, but you look at this research and you have to figure out how to standardize it and then what it is you want to know.
Are you talking about age and race and the education level and things?
Yeah, but that part's that part's easier for analysis than than different
Residence, history, criminal history, residence, criminal history, FTAs. There's like 7 of them. I do, but I didn't bring them either.
But it's
But I
focused
did have
mainly
them.
on criminal history, I suppose.
Well, the residence is a big deal because in Kansas City, you're right there in Missouri, and that gives us real critical. And the other one is a lot of people arrested on I-70 that are not residents, and those are the things. There's a lot of.
Well, that sounds discriminatory if you're handling folks from out of state.
Well, you want to make sure you're going to make court, right?
Californians taking marijuana in New York.
Colorado.
I think the data collection is a little more open-ended, but I'm also not well versed enough to know, what sort of things ought to go into this. The text reminders, our new system, it's called Odyssey, will have that. Because of Cal, I've been talking to them about including bail bondsman, anyone who writes the bond, to be included on the text reminders. I haven't heard anybody yet tell me a reason why we shouldn't do it. I mean, we obviously can do it because it's just adding the phone number in there.
Love to have that.
You know, but I just think it makes sense when you're talking about why have a text reminder if you're not also reminding that what I would call the support system, which is what you guys are, to make sure that somebody shows up. So I think that's there. The question of the summons versus warrants, I hear lawyers like Cal that practiced criminal law for a long time talk about how much more frequently warrants are issued now than they used to be. I think there's something there to look deeper into. Again, these best practices. And then finally, the pilot program. I know that was controversial with you all. There are judicial districts in Kansas that are doing that. We need to figure out how to get it organized and make it work. The task force recommendation was that we take some of these risk assessment programs, like take one and have some pilots and see how it works, just rather than trying to mandate it or pick one, that kind of thing. I think that's a reasonable thing to do. I don't see that on the horizon, honestly, other than we've got some doing it. Yeah.
So,
Yeah.
So, why would one state not take the example of another? California during the pandemic went to zero bail. Our Chief Justice, with all due respect, she's a very wonderful lady, but very politically motivated because her budget is given to her by the legislature and the governor. So she was very politically motivated to eliminate bail in California and said that prior to the task force finding in California. To what Claire said, she packed that task force knowing which direction they were going to go. They did zero bail in California. It did not work. It may turn California into just the worst crime-ridden state in the country, maybe next to New York. Why can't everybody else look at California and what happened and go, that didn't work? It's so much that the state Supreme Court got rid of zero bail as quick as they brought it in, saying this isn't working. Releasing people. There's your pilot program.
No, I mean, but there's more information.
Yes.
Did you notice, when you look at the 19 recommendations of the Kansas Task Force, you'd see what's not recommended? The elimination of cash bail.
That was the bottom line. I was waiting.
Yeah.
I was waiting.
So I'm just saying, the process that I've laid out for you with the people that were on the task force, and I don't think anybody thought it was rigged, this is what they came out with. So again, you can look at this, but I've exceeded my knowledge, and so if you have any other questions, let me.
The Odyssey system, is that what you called it? The court system?
Yeah.
Is that used in other states?
Yes.
Okay, so it's a standardized.
The vendor is Tyler Technologies, the name of which is out of Tyler, Texas. They are the national. They're kind of the gold standard.
Okay, good. So we're going to hopefully end up with a universal functioning.
Different states there are different states that have other types of programs, and we originally had a system called Full Court, and that was what operated in each of the counties, the judicial districts, and so we're now having to migrate the clerks and their muscle memory over how clicks work over to the Tyler system, and it's been a process.
Well, I hope that's going to work out, and that'll be good for you. I bet it will, It is incredibly labor intensive. Right. Incredibly. I mean, it's not only expensive because of what they do, but we've had to put way more people than we ever thought 5 years ago when we picked Tyler as the vendor. Right. Way more people on this to make it work. So, but we will be done. Turn off the recording. We will be done at the end of next year. End of 23.
Yes.
Yes, right.
2023, yeah.
That'd be good.
Yeah.
You know?
We've still got some big counties to bring on, which Sedgwick County, which is one of our big counties in Wichita, Kansas, will come on in the fall. That'll be a huge test. And then Johnson County during 2023. But I think by the end of 2023, we'll have everything up. And then depending on who you talk to,
And it's really good as a bondsman. You got the person, you can look him up, you can see his priors, you can see pending cases. It really helps you, and you can literally do it on your phone. It really is good.
our public portal access is very dynamic. You can literally be, in Johnson County and look and see what's happening out in western Kansas somewhere, or vice versa. And then depending upon your specialized interest, and I'm not trying to say you guys would qualify, I'm just saying if you have different levels of access. If you're the sheriff, you get in a little more than a member of the public in their jammies at home. If you're in your jammies at home, you have less access than if you actually go to the courthouse and use the kiosk, because the internet, we've got layers of this. The press will have greater access to documents, and it's all free. That was the thing that we insisted on. So your access you don't pay like the federal PACER system to be able to get documents. So,
Very good.
so like I say, I've exceeded my knowledge. I'll stand for any other questions, but I'm also trapped with you all for the next few days. So I'll be happy to continue the dialogue. So
This is not necessarily Kansas, but this is a question we always get upset about as bondsmen, is when they say it's a $150,000 bond, but they forget to say it's a $150,000 OR bond, which really is a 1 penny bond. That's a 1 penny bond. There is no monetary obligation because it's an own reconnaissance. I would love for us to figure out a way to let the public be educated, knowing that that person did not post a bond, because it looks like he did, and we don't know how to attack that. Do you have any suggestions? Did I just say it's $150,000?
yeah, I know. But okay. So maybe part of your job is to educate the public. I don't.
Okay.
I don't.
I'm trying.
I think
I'm trying.
that's all part of this thing.
Yeah.
So, thank you all very much for your patience and.
So, with that being said, as I was sitting next to Cal, and it was nice to sit and make comments to each other, I just flashed on why you were here, and I got it. It's to educate us about what we could go do in our state. I wish I had a justice in our court system that was neutral, that didn't have an agenda like you. I really mean that from
That's
my heart.
true.
I really do, because we don't.
Yeah.
And that's why California and New York are in the mess they're in. And I say that, and I don't care how far it goes, that's the problem we have. So with that, Cal, I want to thank you so much. To the Kansas Bail Agency. I just said he's going to be in trouble when he has dinner with me. He might not be able to, he can eat, I won't eat. We're talking, but I hope you all enjoyed that. These are the kind of things we're going to do going forward at PBUS. We don't need any more sheriffs, DAs telling I support bail, I support bail, I support bail. We need to get educated on what we can do to help ourselves. And he still didn't answer that question. I'm going to pry that question out, but thank you very much. Is there anybody else that has anything else?
Any questions?
Any questions at all? Go see how big the smile on Shelly's face is when you see her.
Yeah.
I'm not going to tell you anything, but just go see how big the smile is. And she's buying drinks.
Yep.
I will tell you that.
She must have won. So.
Huh?
Yes,
I didn't say that. I
I
didn't
just
say she
watched
got a whole
it.
one.
There's more material on your thumb drive than what was covered today, and that's what we'll be back with in a couple of days, Dan and I.
We're going to break up into groups, yeah.
So, dinner is at our normal time. I don't know if anybody has anything they want to do tonight or as a group.
Did everybody get
Tomorrow, there's really no planned outings unless somebody, what do you,
Oh,
yes.
Yeah.
I got an announcement.